Let me try this again. Good afternoon, everyone. Welcome to the Assembly Committee on Commerce and Labor. Hope everyone had a great weekend. Ms. LePay, please call roll.
Assemblywoman Backus.
Present.
Assemblyman Carter.
Present.
Assemblywoman Duran.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman Howdegi.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Monroe Moreno.
Here.
Assemblyman O'Neill.
Here.
Assemblywoman Torres.
Here.
Assemblyman Yeager.
Here.
Assemblyman Urick.
Here.
Chair Marzola.
Here. Please mark everyone present. Everyone, welcome for everyone who's here in Carson City, those joining us by video conference in Las Vegas, and anyone tuning in through the internet. Today we will begin with an overview of the State Contractors Board. Then we will hear three bills: Assembly Bill 27, Assembly Bill 29, and Assembly Bill 31. Before we get started, I would like to make a few housekeeping announcements. Please silence all of your electronic devices. Members of the public may provide testimony in various ways, all of which are listed on the agenda. For those testifying online, please be sure to mute your microphone when not speaking to minimize any background noise. When testifying, please turn on your microphone and clearly state your name and affiliation, if any, for the record. Then turn off your microphone when you're done speaking. If you have handouts for the committee, please provide 20 copies to the committee secretary prior to your testimony. In addition, exhibits and amendments must be submitted electronically as a PDF to our committee manager no later than noon the business day before the meeting. Also, I would like to remind members of the committee they must be recognized by the chair before they speak. This includes all questions, comments, and requests for follow-up questions. I expect courtesy and respect in our interactions, even if we may not agree. Lastly, committee members will be using their laptops to view handouts and other documents. Please do not view this as a sign of disrespect or inattention. With that, we will move to our first agenda item. First, we have a presentation by the State Contractors Board. Joining us today is the Executive Officer, Margie Green. Please begin whenever you're ready.
Good afternoon, Chair Marzola and members of the committee. My name is Margie Green, and I've had the pleasure of serving as the Executive Officer of the Nevada State Contractors Board for the last 25 years of my 37-year career with the board. On behalf of the Contractors Board, I'd like to express my appreciation for the opportunity to provide you with an overview of our board that addresses our mission to promote public confidence and trust in the competence and integrity of the licensees while protecting the health, safety, and welfare of the public. My presentation today, I guess I should introduce Misty while I'm here. Go ahead, Misty.
Misty Grimmer with the Ferraro Group, representing the Contractors Board.
Thank you. My presentation today will provide you with an overview of the operations of the board and touch on some of our recent accomplishments and activities. Hopefully you all have a copy of the handouts I've provided to the committee. These provide you with a high-level overview of our legislative package, our constituent services, operational highlights, and the board's 2022-23 strategic plan. If there's no any questions, I'll go ahead and get started.
Please.
Thank you. The Nevada State Contractors Board was established by the legislature in 1941 and is comprised of 7 members, including 6 licensed contractors and 1 representative of the general public. Each member is appointed by the governor for a 3-year term. Our board meets monthly to provide staff direction on policy and governance matters, in addition to developing an annual strategic plan that outlines goals and objectives to be achieved each fiscal year. We have a number of subcommittees that meet as needed, with the exception of the Residential Recovery Fund, which meets every other month, and is comprised of 3 board members. The Contractors Board is self-funded with revenue received from licensing fees. We are not part of the general fund budget, although we do remain part of the executive branch of government. Our board has maintained an operating reserve policy since 1948, which has been modified over the years based on recommendations received by our auditors, as well as the Legislative Sunset Committee, to comply with the most current financial statement reporting requirements. The current reserve policy requires an annual analysis of the ratio of the unrestricted net assets and the board's operating expenses at fiscal year end during the annual audit. The board employs 58 personnel between our two offices in Reno and Las Vegas, and we maintain our own benefit and retirement plans. The Contractors Board has never been a part of PERS since inception in 1941. However, we've been an active participant in Social Security since 1952 and offer both the 401A employer-funded retirement plan as well as a 457B employee-funded retirement plan. Since construction was deemed an essential industry during the COVID-19 pandemic, the Nevada State Contractors Board remained open and continued to serve the public without interruption. We currently license over 17,800 construction businesses in the state of Nevada, including both residential and commercial contractors. Licensees consist of corporations, LLCs, partnerships, and sole proprietors. Of the 17,885 license holders, approximately 35% are from out of state and 65% are from Nevada. Each of the licensed entities are directly responsible for the hiring and employment of the estimated 105,000 workers in Nevada's construction industry. Our licensing process includes, among other requirements, a review of the applicant's experience, financial wherewithal, and character. Applicants are required to take and pass any required trade exams, as well as the business and law exam, which tests the applicant's understanding of applicable state laws and knowledge of operating a business. The license classifications range from specialty licenses, such as plumbers and electricians, to general contractors. Projects can range from small home repairs to large-scale building projects, such as the Allegiant Stadium. To give you an idea of the work performed by our licensing division during the past fiscal year, approximately 5,330 new licenses and license change applications were received, and over 7,600 license renewals were processed. Making licensure more accessible for those who have an interest in starting a construction business in Nevada is something the board remains committed to. The board continues to provide assistance to those wishing to enter the profession through our Small Business Assistance Program classes. This forum allows first-time applicants to gain a better understanding of the application process and receive guidance concerning requirements related to starting a business. Our Veterans Assistance Program offers specialized services to veterans, military families, and veterans returning to civilian life. Each of these services seeks to expedite and minimize the application process. Through our annual strategic planning sessions and participation in various focus groups and committees, the board has established ongoing initiatives to improve our services. Over the past several years, we have implemented a number of legislative, regulatory, and procedural changes aimed at removing barriers to licensure and streamline our application process. Those changes have included implementing a licensure by endorsement program that recognizes certain experience and completion of exam requirements from 12 other states, working with our exam provider to allow applicants to take Nevada-based exams at any of their approved facilities across the nation, which has provided a cost saving for many of our applicants. Amending the administrative code to expand acceptable experience documentation to include a master's certification in a discipline substantially similar to the requested classification, and allow credit based on completion of a training program for occupational, vocational, career, trade, or technical education. The board also identified a need to serve both consumers and the industry by establishing a classification specific to residential remodeling work. We believe this category of licensure will provide more choices to homeowners seeking to have smaller remodel work performed and provide opportunities for smaller contractors looking to enter the profession. This classification was approved by the Legislative Commission last year, and we are currently accepting applications from interested businesses. In addition to our licensing efforts, our board maintains a responsibility to ensure that those that we license comply with the statutory and regulatory provisions under NRS and NAC Chapter 624. Our enforcement division includes 3 departments. The compliance department investigates all complaints received by the board related to licensed contractors, which typically fall into one of three categories. Workmanship complaints coming from property owners, which may include, but not limited to, abandonment of a project, failure to correct, workmanship issues, or failure to complete contractual obligations. Money owing complaints involving contractors, subcontractors, vendors, and suppliers, and also violations of industry regulations. These offenses usually include violations of building code, such as failure to obtain a permit, hiring or doing business with an unlicensed contractor, or failure to maintain industrial insurance. Our criminal investigations unit investigates all unlicensed contractors' complaints and may forward validated cases to the local district attorney's office for criminal prosecution or take administrative action. In addition to investigating complaints, our criminal investigators coordinate operations to proactively address the underground economy by performing job site visits and monitoring a variety of electronic means where construction services are being advertised, such as Craigslist, Facebook, and other online bulletins. The board's fraud unit is charged with taking on significant complex cases of unlicensed contractors who prey upon unsuspecting homeowners, often senior citizens, by committing felony crimes and including obtaining money under false pretenses, diversion of funds, or property theft, among other things. The fraud unit also assists licensed contractors who have been victimized by embezzlement through criminal activity, such as theft, diversion of funds, forgery, and misrepresentation. During fiscal year 2021-22, our enforcement division received 2,115 complaints, processed nearly 3,400 fingerprint cards, and performed 230 background investigations. A total of 383 administrative citations were issued. We filed 50 criminal cases with the district attorney's offices, issued 287 cease and desist orders to persons operating without a license. Additionally, the board held 100 disciplinary hearings, which resulted in revocation of 35 contractor licenses and fines assessed of more than $261,000. The money received from disciplinary fines is deposited into the construction education account and is distributed by the Commission on Construction Education in the form of grants to community, educational, and industry-affiliated organizations wanting to implement and promote construction education and workforce development programs in the state of Nevada. The commission is comprised of a total of 7 members, 1 member who is a member of the board, and 6 members appointed by the governor as follows: 4 members who represent the construction industry and 2 members who have knowledge of construction education programs. In fiscal year 2021-22, the Commission on Construction Education awarded nearly $227,000 in grants. The commission has awarded a total of $4 million since inception in 2001. Additionally, the Residential Recovery Fund Subcommittee considered 85 claims this past fiscal year and awarded just over $767,000 to harmed homeowners, many of who were senior citizens who were taken advantage of or homeowners who had their projects abandoned. The Recovery Fund is such an important protection we have for owners of single-family residents who hire licensed contractors, because it allows them to receive financial recourse up to $40,000 without having to go through civil litigation. Since the first claim was paid in 2001, the Recovery Fund has awarded over $14.5 million to harmed homeowners throughout the state. And I can tell you firsthand, there's no greater feeling than helping a homeowner who has been harmed by an unscrupulous contractor. While much of our work centers on the accountability of our licensees and regulating their ability to follow the laws of the state, our greater purpose and outcome is measured by the people we protect each and every day. We have developed a number of innovative programs to further our mission and goals. Some of these programs include the creation of an underground economy task force comprised of various state, local, and industry partners focused on combating the impacts of unlicensed contracting, which often target our most vulnerable citizens and harm the credibility of the industry. We've partnered with the Attorney General's Bureau of Consumer Protection to address solar complaints, and also the implementation of Senate Bill 303 from the 2021 session. Public relations campaigns aimed at informing consumers and contractors concerning the enhanced protections and contract requirements related to our residential solar projects. A senior awareness program that addresses construction-related scams and highlights the free resources available by the board. A home improvement forum that brings together industry professionals and the contractors board together to highlight the importance of hiring licensed contractors for homeowners of all ages looking to engage in home repairs or remodel projects. Construction career panels to educate and inform at-risk populations, students, and others about employment in the construction industry and how this is a viable career option. Legislative town hall events to help raise awareness of the board resources and related public safety initiatives and programs. Topics in these forums include the value of hiring a licensed, not unlicensed, contractor, home repair scams, how to identify them, as well as Nevada's Joint Task Force on Labor. Our Hammers and Hope event highlights the many construction industry career opportunities for women in the community, with a particular focus on women in need. We also make an effort to meet with various industry associations to share our objectives and activities of the board, seek their input, and proactively address concerns of relevance to the board as well as the industry. As noted earlier, it is the Contractors Board's vision to be a model regulatory agency, which is why we engage ourselves in the annual strategic planning discussions to reflect on environmental changes and recent experiences in order to continue advancing the services of the board. We're proud of the efforts the board has made to protect the public and continue to make and promote the integrity of the industry. I'd like to thank you again for allowing me to present today, and I'm more than happy to answer any questions.
Thank you so much for your presentation. Any committee members have any questions? I see no questions. So we will now open the hearing on Assembly Bill 27. This measure revises provisions relating to contractors who provide management and counseling on construction projects. Ms. Green, you may begin.
Thank you, Chair Marzola, members of the committee. Again, Margie Green, Executive Officer of the Nevada State Contractors Board. Assembly Bill 27 seeks to amend the language in NRS 624215 as it relates to construction management and counseling services. This bill is primarily housekeeping in nature and is intended to ensure that a construction manager is properly licensed and skilled for the type of construction project covered by the contract. The lack of specificity in the current language, which was passed in 2019, was questioned by an administrative law judge in a disciplinary proceeding and resulted in a decision that a licensee holding any one of the general building classifications could act as a construction manager on any type of construction project. Under this ruling, it is feasible that someone holding a license classified for pre-manufactured housing or residential remodeling with only these limited skill sets would be permitted to act as a construction manager or the construction of a high-rise hotel casino or other significant complex project. It is clear that this decision that came down poses a significant health and safety risk to the public. This amendment would remedy the unintended consequence and ensure that the work is only performed by licensees with the proper qualification and skill set based on the scope of work. And I'm happy to answer any questions.
I do have a couple questions from committee members. Vice Chair?
Thank you, Chair. Nice to see you, Ms. Green. Could you give me an example of how this would work, like, or what this looks like? So if someone's supervising a project, they would have to have a license, like as a plumber and as like for electrical work and for HVAC work. Am I understanding that correctly?
Thank you, Vice Chair Howdeke. If you look at the bill in section 5 or 6A, or starting with 6, the current language states, "A general building contractor may contract to provide management and counseling services on a construction project for a professional fee. A general building contractor who is contracted to provide management and counseling service." So that only narrows it down to the general building contractor. So a construction manager is normally say it's a high-rise project, and that full license classification is a full B, which can build high-rise construction. The problem that happened with this particular case that we had is a small residential contractor was performing work as a construction manager on this high-rise when he didn't have the skill set or qualifications on that type of project. So that's where it would come into play. It's simply for the general building contractor, and it has to be of the same classification. So if it's a B contractor on a high-rise, the construction manager who's hired to oversee the project and all aspects of the work would have to have that same skill set as a B contractor. Does that make sense? Yes. Okay, thank you.
Assemblywoman Backus?
Thank you, Madam Chair, and thank you, Executive Green, for your presentation. I do have kind of a follow-up just to make sure it's clear to my colleague. An example, and I get what you're saying on the general side, so a B2 classification for a residential builder couldn't oversee something that would require a B license. But what about the situation where you have a general contractor who is, the prime contractor is performing also, let's say, like carpentry under a C3 license? Is the intent of this language to now mandate the construction manager to also maintain both maybe the B license and a C3, or is it just sufficient that we're just comparing B licenses like an AB to an AB and a B to a B or a B2 to a B2? Thanks.
Thank you, Assemblywoman Backus. Assemblywoman, did I say man? I'm sorry. You're correct on that. So a general contractor, a B contractor could perform those service or that work that a C contractor could. So they wouldn't have to have a separate license for that.
Any other questions? Assemblywoman Kusama?
Thank you. In the example you gave with the lawsuit that this kind of came about, was the issue that happened that caused the lawsuit because this person didn't have all the licenses of the main contractor, or was that just something to the side that came up because of this lawsuit, if that makes sense?
Thank you, Assemblywoman Kusama. Is it okay if I answer them directly, or do we do through the chair?
You can go ahead and go
Okay,
direct.
thank you. So in this particular case, the complaint itself was about a B2 contractor acting as a construction manager on a B project. That was the crux of the complaint. So there were no other issues with that as well. Well, I believe there was one other issue with the building permit, but that one was resolved. So it was simply that there was an out-of-scope contractor performing work as a construction manager on a high-rise.
Thank you.
Any additional questions? I don't see any. So we will hear testimony in support of Assembly Bill 27. Each person will have 2 minutes to provide testimony. Is there anyone here in Carson in support?
Thank you, Madam Chair. My name is Alexis Motorex with the Nevada Chapter Associated General Contractors, representing the Commercial Construction Trade Association in Northern Nevada. We are here in support of AB 27 as we believe that any contractor providing management and counseling services should have the expertise and an active license in each classification or subclassification required by the prime. It's common sense, it protects the public, and we encourage your support. Thank you.
Thank you. Anyone else in support of Assembly Bill 27? Anyone in Las Vegas in support of Assembly Bill 27? I don't see any. How about PBS? Is there anyone in support on the phone lines?
Thank you, Chair. To testify in support of AB 27, please press star 9 to take your place in the queue. Again, if you wish to testify in support, please press star 9. Chair, there are no callers for support at this time.
Thank you. We will now hear testimony in opposition of Assembly Bill 27. Is there anyone here in Carson City? There's no one here in Carson City. Is there anyone in Las Vegas in opposition to Bill 27? PBS, is there anyone in opposition on the phone lines to Assembly Bill 27?
To testify in opposition of AB 27, please press star 9 to take your place in the queue. Again, if you wish to testify in opposition, please press star 9 now. Chair, we have no callers for opposition at this time.
Thank you. We will now move to neutral. Is there anyone here in Carson City to testify in neutral of Assembly Bill 27? Is there anyone in Las Vegas? Is there anyone on the phone lines to testify in the neutral position for Assembly Bill 27?
To testify in neutral for AB 27, please press star 9 now to take your place in the queue. Again, if you wish to testify in neutral, please press star 9. And Chair, we have no callers for neutral at this time.
Thank you. Ms. Green, would you like to do any closing remarks?
Thank you again for allowing us to present this bill, and it is effective upon passage and approval, so we just urge your support. Thank you.
Thank you. I will close the hearing on Assembly Bill 27. I will now open the hearing on Assembly Bill 29. This measure revises the grounds for disciplinary actions against a licensed contractor. Ms. Green, you may begin when you're ready.
Thank you, Chair Marzola and members of the committee. Margie Green again on behalf of the Nevada State Contractors Board. Assembly Bill 29 would amend NRS 624-3016 by adding a cause for disciplinary action for making a false or misleading statement or representation or knowingly admitting a material fact in connection with the application of another person. Since the experience validation process also often requires references or employment verifications by other contractors, preserving the integrity of this process is important and is in the best interest of the industry and Nevada consumers. During some recent background and experience investigations, we have discovered some questionable and even falsified documentation. The proposed amendment would provide the board with an additional tool to to deter this type of activity. And I'm happy to answer any questions you may have.
Thank you for your presentation. Assemblywoman Monroe Moreno has a question.
Thank you, Madam Chair. In your statement, you said that you've seen some fraudulent information. Can you tell us how often that happens? Is it a growing thing? Has it grown since the pandemic as we're reopening and new things coming on?
Thank you, Assemblywoman. Do not have those facts.
Ms. Green, I'm sorry. Can you state your name for the record?
Margie Green. Thank you. Sorry about that. I have not seen, I do not have the numbers on that. It's been a problem we've noticed over the years, and there's nothing we can really do. Say, for example, there's no education component of being a licensed contractor. It's simply the exam and experience. So we have to put a lot of credibility and look to those providing references and employment verifications to ensure that that person has the requisite experience and qualifications to perform the type of work he's applying for a license in. We've noticed a few contractors who, and sometimes it's intentional, sometimes it's not, but this would just help us ensure that those qualifications are, it's just going to give us another tool to ensure that the qualifications are as stated on that reference.
Yes, go ahead.
Thank you. And would this apply only to the applicant or to the references as well?
This allows us to take disciplinary action. Again, Margie Green for the record. This allows us to take disciplinary action against those providing the false references or qualification verifications.
Mr. Speaker.
Thank you, Madam Chair. So in 14, I certainly understand knowingly making or causing to be made any false or misleading statement. I'm trying to wrap my head a little bit around the knowingly omitting any material fact. And so I guess my question is, in the context of either an applicant or someone who's providing a reference, what kind of obligation are they under to actively provide information? Do you ask them certain questions? And so I'm just trying to get a sense of what the omitting part of this is getting at in practice.
Thank you, Margie Green, for the record. Mr. Speaker, the knowingly, I believe, clarifies that if someone is, and this would be an action we're taking against the person providing the reference, not necessarily against the applicant. The applicant would be misrepresentation of a material fact if he provided a false information. So this particular statute, or that we're attempting to change, is addressing those that provide the false reference. Knowingly is defined in 624. I really can't answer that from a legal standpoint.
Go ahead, Mr. Speaker.
I think I might have asked the question in a confusing way. It wasn't so much to knowingly, but it's this knowingly omitting. So, omission is right when you're supposed to disclose something and you don't. You withhold information rather than you're actively providing information. So I'm just wondering, like when you talk to references for folks, how does that process work? I'm just trying to think like what piece of information the person would have and not disclose to you. Because certainly if they lie to you about something, that makes a lot of sense. You would discipline them. But this sort of, to me, implies that they have an obligation to tell you things, and if they hold back from telling you those things, then you could take discipline. So I'm sorry if it was confusing. I'm just trying to wrap my head around between what they affirmatively tell you versus what they're supposed to tell you and maybe don't, and then you take action on that. That's not me. That's not me. Okay. Good job.
Thank you, Margie Green, for the record. I don't have an answer to say knowingly omitting. I'm just trying to think in my own head of a reference where perhaps they know a person didn't have, let's just take an electrician, for example, that this contractor, this was an employee of his, and perhaps this applicant maybe performed office work, and he wasn't an electrician. And so would he, by signing that reference, and I'm just trying to think through an example of something like that. He knowingly signs the reference knowing that this individual was not an electrician or didn't have the skill set for that or the 4 years experience. Did that answer your question? Okay, thank you.
Assemblyman Carter.
Thank you, Madam Chairman. Why is this only addressing the affirmative side? Why doesn't it address penalties for somebody who knowingly submits a false representation trying to limit competition or deny somebody an application for a contractor's license?
Margie Green for the record. Could you rephrase that
So
for me?
Excuse me, this is Max Carter again. So the last sentence says, for the purpose of assisting the applicant to obtain a license. What if the person is submitting a false representation trying to impede that person from getting a license? Why isn't that included in here also?
Margie Green for the record. I believe to answer that, the applicant is the one that submits the references, gets the references. For example, you are his employer and he submits you the reference. The references don't come in on their own. It's part of the application process. They have to supply 4 references to support their experience. So I've never seen a situation where that would come into play, in my opinion. But
Okay, thank you.
thank you.
Assemblywoman Backus.
Thank you, Madam Chair, and thank you, Executive Green, for this language. My question for you is, sometimes with respect to these licensure applications, the concealment, especially the knowingly concealment, may not be discovered within the statutory period of 4 years. Has the board contemplated expanding NRS 624.331 subsection 1 to contemplate when the fraud may be discovered?
Margie Green for the record. Thank you, Assemblywoman Backus. We have not, but that's a good point. Thank you.
Assemblyman O'Neill.
Thank you, Chair. I appreciate it. On the last page, last paragraph, 14, misleading, the misgiving, causing any false or misleading statement. It's the word misleading that I question. To me, that's very open to interpretation about what I may consider misleading on what you say versus somebody else. I don't think I gave you a misleading statement, but it's open to your interpretation. And I find that troublesome when it's on such an important document for a person's license. Can you explain to me your definition of misleading?
Margie Green for the record. Again, this is not a legal definition of it, but the knowingly making a misleading statement, in my mind, is that they know that they're falsifying that reference. By just, it's the form itself, they're certifying that that information is true. So I would assume most people, before they fill that out, know whether they're giving a misleading statement or not. That's, again, I'm not giving a legal opinion on it, just from what we see.
And I will admit, I try to get onto Black's Law Dictionary, and website won't let me on there to get the legal interpretation of the word misleading. So I appreciate it. I understand falsifying. It's just misleading to me is very open to interpretation. Thank you, Chair.
Assemblywoman Torres.
Thank you. We're all a little off, so we're not quite centered with our mics anymore. Thank you for the presentation and introducing the bill. So I just had a couple questions. So the first, just so I make sure that I understand clearly, I just want to make sure, so this applies to the references. This doesn't actually apply to the applicant. This is just applying to the individuals that are referring or talking about that applicant, correct?
Margie Green for the record, that is correct.
Thank you. And then I do have a concern because there's nowhere in here stating that that reference would even be made aware that there would be such a penalty. So, I mean, I get called working with young people all the time. Like, I'm often a reference on job applications. And, like, if I was contacted as a reference, there's nothing guaranteeing in here that that reference would even know that these penalties exist. And I guess I do have concerns about, like, a reference possibly facing penalties that they might not know exist, when oftentimes that, like, I'm sure that there's some type of information that's required from that reference, but I just would like to see language in here that guarantees that that individual knows, because you're giving somebody now a responsibility and saying that there's penalties just because somebody else said that you are a reference.
Thank you, Margie Green. For the record, we will amend our reference certificate form if this bill should pass, so that the reference provider, which is the contractor, will know what the penalties are and what the law says.
Any other questions? I have one. How often does this happen, to where there's misleading statements in these applications?
Thank you, Margie Green. For the record, I don't have the numbers on that, but it is fairly frequently. And at the time, we were looking at it, trying to determine if this reference is valid. And we spot check them occasionally, and maybe someone else may say, I know this person is just doing construction cleanup. They're not a contractor. So I don't have the exact number on that. I can get that for you and report back if that's something you'd like.
Yes, please, if you could submit it to the committee manager. Thank you.
Thank you.
There are no other questions. Next, we will hear testimony in support of Assembly Bill 29. Each person will have 2 minutes of testimony. Is there anyone in support of Assembly Bill 29 here in Carson? Is there anyone in Las Vegas in support? BPS, is there anyone on the phone lines in support of Assembly Bill 29?
To testify in support of Assembly Bill 29, please press star 9 now to take your place in the queue. Again, if you wish to testify in support, please press star 9. Chair, there are no callers in support at this time.
Thank you. We will move to opposition of Assembly Bill 29. Is there anyone here in Carson City? Anyone in Las Vegas in opposition to Assembly Bill 29? BPS, is there anyone on the phone lines in opposition?
Testify in opposition on AB 29. Please press star 9 to take your place in the queue. Again, if you wish to testify in opposition, please press star 9. Chair, there are no callers for opposition at this time.
Thank you. We will move to neutral testimony for Assembly Bill 29. Is there anyone in Carson City wanting to testify in the neutral position? Anyone in Las Vegas? BPS, is there anyone on the phone lines wanting to testify in neutral?
Testify in neutral for AB 29. Please press star 9 to take your place in the queue. Chair, there are no callers to testify in neutral at this time.
Thank you. Ms. Green, would you like to give any closing remarks? I will close the hearing on Assembly Bill 29. I will now open the hearing on Assembly Bill 39, which is our final bill on the agenda today. The measure revises provisions relating to contracts for work concerning certain residential improvements. Ms. Green, you may begin.
Thank you, and good afternoon again, Chair Marzola and members of the committee. My name is Margie Green, Executive Officer of the State Contractors Board. I'm here today to testify in support of Assembly Bill 39, which aims to strengthen protection for consumers looking to contract for certain residential improvements. Residential contractors are most relied upon by consumers, the consumers we serve. They're the ones we invite into our homes, who we call in our time of need, and who help to restore our environment to a comfortable norm. It is because of the variety of contracted work required to sustain a home that the Contractors Board believes consumers deserve to have a standard contract expectations that guide their best interests and ensure the contract is enforceable for both parties. A common trend noticed among the complaints filed with our office is validation of overpayment. When too large of a down payment was made, up to 50% of the contract price, or payments in excess of the amount of work completed, we know most homeowners would benefit from specific contract terms, guaranteeing important project details are defined and agreed upon upfront. To illustrate between fiscal years 2018-19 and 21-22, the Contractors Board validated 135 complaints of contractors accepting money when little or no work was performed, resulting in damages to residential homes in excess of $1 million. I think it's important to note that these are only representative of homeowners who have chosen to contact the board with their concerns. AB 39 speaks on behalf of all homeowners facing these circumstances and offers them protection from becoming our next statistic. Following the investigative process, eligible consumers have access to the Residential Recovery Fund. Created by the legislature and enacted into law into 1999, the Recovery Fund provides monetary relief to qualified homeowners the board finds financially harmed by licensed residential contractors. Each of those 135 cases I referenced had their claims heard by the Recovery Fund Committee, and a total of $1,057,700 was awarded, validating financial harm incurred. This award alarmingly represents 32% of the total amount awarded to homeowners from the Residential Recovery Fund during that 4-year period. The Contractors Board favors new requirements proposed in AB 39. Among those include limiting initial down payments or deposits not to exceed $1,000 or 10% of the aggregate contract price, whichever is less, documenting the estimated date of completion, writing a description of work to be performed under the contract and any change orders incorporated, and specifying the total amount to be paid for the work under the contract. AB 39's provisions provide necessary safeguards that enhance consumer protection while reducing the gray area often caused by miscommunication and poor contracting practices. The Contractors Board finds the language specific to residential improvement projects to be sufficient and appropriate, given that the enhanced statutory requirements for new residential construction, work concerning residential photovoltaic systems and contracting for residential pools and spas already exists under NRS 624855 and 624915 respectively. These areas of the construction industry were addressed and improved following similar rises in complaints with concerning trends. In the 1990s, we noticed an increase in pool construction complaints, and laws were passed in 1997 and 2001 addressing those concerns. And again in 2021, when solar contracting issues trended upward, Senate Bill 303 was passed with the help of Senator Brooks to address problems in the solar industry. Just as we have experienced in both the pool and solar industries, once contract requirements were standardized, the industry responded to heightened accountability by fulfilling the new statutory expectations. It is our belief that AB 39 will achieve the same outcome, and we will begin to see a noticeable decrease in the complaints filed with the board against licensed contractors performing residential improvement work who took down payments from homeowners without performing any work or providing any materials. AB 39 is a consumer protection win for Nevada, but it is also an opportunity to standardize contracting for Nevada contractors, affording businesses of all sizes to have confidence in the work they are engaging in. And again, I am happy to answer any questions you may have.
Thank you for your presentation, Vice Chair.
Thank you, Madam Chair. And I just have one quick question. And so this is very similar to my pool contract. I signed my pool contract. I gave a $1,000 deposit. This contract just doesn't exist for remodeling of single-family residential projects. And so it's basically taking something that we already do for some types of projects and making it for a kitchen remodel as well. Am I?
Thank you, Margie Green. For the record, that is correct.
And if I could have a follow-up, Madam Chair? And Ms. Green, and why is it only applying to single-family residences? Why isn't it applying to townhomes or condos, or do they also fall under that SFR definition?
Thank you, Madam Vice Chair. They have defined single-family residence as it's defined in NRS 624455, and that came, I believe, from LCB. Because there was no other definition in it. So single-family residence would apply to the interior work performed in a condo or townhouse, not to the exterior work. And that was the reason for that.
Assemblywoman Backus.
Thank you, Madam Chair. My question is kind of broad, and I know you kind of covered it, but I just, for the legislative history, I want to make sure that I fully understood what the reasoning was behind creating this specialized legislation for residential builders who are only doing remodel work.
Margie Green, for the record. Thank you, Assemblywoman Backus. As this has evolved, and we have seen more and more complaints, and as I mentioned, the statistics for our claims against the Residential Recovery Fund, more and more improvement work, and it's not coming from the builders. It's not coming from commercial construction. It's coming from those residential remodels like patio covers, kitchen cabinets. As I mentioned, that was the issue. We had a huge issue with the pools. Legislation was passed to address it. A huge issue with solar. And now we're looking back, as we go through our records, we initially were going to just submit a bill that only limited the down payment. But working with LCB, we agreed that it was standard that we follow the similar provisions to address residential remodel as it did with the pools and the solar. We just don't see in the complaints that are coming forward, complaints where the contractor takes no money and does no work or leaves the project unfinished with major residential builders or someone that's building an entire home. We do see that in the remodel work, and that's the purpose of this legislation.
Thank you, Madam Chair. May I ask a follow-up question?
Yes.
And looking at that, and I see where where the language has expanded on what needs to be in the contract, and that part of the penalty if a contractor fails to include one of these multiple items, and let's say, for example, subsection L, where if the contract doesn't have that the obligation of the owner is to make payments in accordance with the payment schedule, is voidable. If that language does not appear in the contract, then as I understand this, the whole contract becomes voidable. And as I understand, voidable contracts usually go to something that's against public policy. And my question is usually when we're looking at remedies, when there's a voided contract, is to put someone back in the place that they originally were before they contracted. And in situations like this, contractors may expend lots of money to already start doing the work, whether it's already securing materials and paying labor. And so I'm kind of curious how you're looking at when a contract is deemed voidable. How does that work? I'm just kind of curious. Thanks.
It's Margie Green for the record. It's my understanding that the homeowner has the right to void the contract, The Contractors Board does not void the contract. And I'm not certain, again, this is a legal question, if they were going to void that contract, does it have to go through a court of law to void that contract, or I'm not certain how that works. But it's the same provisions we have in those other two sections concerning pools as well as solar. I'm sorry, I can't give you a clearer answer.
Assemblyman O'Neill.
Thank you, Chair. I've got to follow up on the previous question. So let me understand, if for some reason the contract is voided for failure to, oh, there's so many things in here, one of these pieces that I didn't put in the contract, that you can contact an attorney to read the contract before signing it, which to me is an assumption. So the contract is voided, but the contractor has already put in $4,000, $5,000, $6,000, $7,000, $8,000 worth of work. Is that contractor paid for the work performed then up until the time contract is voided?
Marky Green for the record. If the contractor has followed the payment schedule in the contract, then he would be paid for the work performed. I am not certain how that would come into play. Again, that's a legal question that maybe someone in here can answer.
May I have one follow-up, please?
Go ahead.
Thank you, Chair. The language here you keep saying is the exact same language that's already in statute for contractors who do swimming pools and solar?
Margie Green for the record, it's very similar. It's not quite identical because there are different provisions that go into pool contracting and solar versus residential, but it's very similar.
I misunderstood your prior statement, and I appreciate that. Thank you, Chair, for the time.
Assemblywoman Kusama.
Thank you, Chair. Thank you again for your overview here. And I understand what you're trying to do, because we do have people out there that are being taken advantage of, where the contractors come in and they pay a lot of upfront money and they never see them again. So I know that that's an issue. I just have a concern for the contractor side. If he has to go order, a $5,000 HVAC system or a fancy appliance, the Viking Sub-Zero, and then he's ordered that, and then the owner says they're not going to pay for that. If he can't at least get the money to cover the material, I'm just concerned, because we have the one side where we want to protect the consumer, and I get that, but what about the contractor who goes out and puts the money up front for expensive material, and then the owner decides, I don't want this anymore, or something has changed, and then he's out that, possibly.
Margie Green for the record. Thank you, and I do understand your concern. I do not have an answer to address that problem for the specialty order items.
Thank you.
We're actually going to have legal step in.
Thank you, Madam Chair. Sam Quas, Committee Counsel. So the provisions of this particular section, as well as the other sections that are similar, don't specifically spell out how this is going to work. But what I believe what would probably happen here is that the general principles of contract law would govern the voidability of this contract. So if the homeowner in this instance decided to void a contract, and not having looked in any of the specific cases, and any time this has come up in the previous with respect to the other provisions, I believe what would happen would be that the principles of contract law would govern, which don't allow a person to just obtain a windfall and something for nothing. So I believe that those would be worked out in court by a judge, who would then determine if someone were to spend a lot of money on materials or something like that, The principles of contract law would not allow that person to just have all that, have all those materials without people being put in the proper place under law. So I believe they would have to pay some sort of compensation as determined by a court.
Thank you. Assemblywoman Duran. Any other questions? There are no additional questions. We'll open in support of Assembly Bill 39. Anyone here in Carson City in support for Assembly Bill 39? Anyone in Las Vegas in support of Assembly Bill 39? BPS, is there anyone on the phone lines in support for Assembly Bill 39?
Testify in support of AB 39. Please press star 9 now to take your place in the queue. Chair, there are no callers in support at this time.
Thank you. Next, we'll hear testimony in opposition of Assembly Bill 39. Is there anyone here in Carson City in opposition? Is there anyone in Las Vegas in opposition to Assembly Bill 39? I don't see any. BPS, is there anyone on the phone lines in opposition?
To testify in opposition of AB 39, please press star 9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you. We will move on to neutral testimony. Is there anyone here in Carson City to testify in neutral for Assembly Bill 39? I don't see anyone. Is there anyone in Las Vegas? I don't see anyone. BPS, is there anyone on the phone to testify in neutral for Assembly Bill 39?
To testify in neutral for AB 39, please press star 9 now to take your place in the queue. Caller, please go ahead. You are unmuted on our end, caller. You can make sure that you are unmuted on yours.
Yes.
You are unmuted. Please go ahead.
Okay. This is Eva, or excuse me. Thank you, Madam Chair. This is Eva Segerbloom on behalf of Nevada Justice Association. We are neutral to this bill, AB 39. We believe the intent is good in terms of offering more protections for consumers, but we think that the bill could go further in terms of protecting both homeowners and contractors by adding a prevailing party provision for attorney's fees, as well as making sure that these contracts do not include forced arbitration. And that's why we are neutral on this bill and hope that we can potentially work on an amendment. Thank you.
Thank you. Is there anyone else in the phone lines?
Chair, there are no additional callers for neutral at this time.
Thank you. Ms. Green, would you like to have some closing remarks?
Margie Green for the record. I would just like to thank the committee for allowing us this time to present our bills and also the overview of the board. And I'm happy to work with anyone who has any suggestions for improvements on any of our bills, and I'm available. Thank you.
Thank you for your presentation. I will close the hearing on Assembly Bill 39. I will now open up for public comment. Please address your remarks to the issues that fall within the jurisdiction of this committee. We ask that public comments be kept to 2 minutes so that everyone interested in speaking can be accommodated. Public comment may be submitted in writing either in addition to testifying or in lieu of, before, during, or up to 24 hours after our meeting has adjourned. Please remember to state and spell your name for the record and indicate your affiliation, if any. For those persons wishing to provide testimony telephonically, please call 669-900-6833. When prompted, enter the meeting ID 832-520-77259. Then press pound. Is there anyone here in Carson City that wishes to give public comment? I don't see anyone. Is there anyone in Las Vegas? I don't see anyone in Las Vegas. Is there anyone on the phone lines, BPS?
Chair, the public line is open and working, but there are no callers at this time.
Thank you, and thank you everyone for attending this meeting today. That concludes our meeting. Our next meeting will be Wednesday, February 15th at 1:30 p.m. This meeting's adjourned.